Good morning. Welcome to Labor Health and Social Services Committee. Welcome members of the committee and members of the public. Thank you for joining us this morning. Good morning, Mr. Caldwell and Ms. French. Thank you for being our support this morning. We'll go ahead and call the meeting to order, and Mr. Caldwell, if you'd call the roll.
Representative Clauston.
Here.
Representative Guggenmoss. Representative Heft. Representative McCann. Representative Ottman. Excused. Representative Thayer.
Here.
Representative Wasserberger.
Here.
Representative Yen.
Here.
Chairman Rodriguez-Williams. Madam Chairman, we have a quorum.
Thank you, Mr. Caldwell. For those of you just joining us for the first time, we do have rules of decorum that are listed out front of the meeting room. They will apply to everybody in the audience, our committee, and those that are joining us online. I'm going to briefly go through a few of them. Committee members, speakers, and audience members will conduct themselves in a civil and respectful manner at all times during this meeting. The speakers will address all comments and questions to the chairman. Speakers will refrain from the use of individual names. Comments will be directed to the issue under consideration. Testimony that strays far from the topic will be called out of order. Speakers will refrain from making comments of a personal nature that reflect upon character or conduct of a committee member or another speaker. Personal criticism, ridicule, and name calling is forbidden. Speakers will refrain from use of indecent or obscene language, fighting words, or other language which is disruptive to the orderly discussion at the meeting. Time limits for addressing the committee may be imposed and will be imposed depending upon the committee's agenda and the number of presenters. Audience members will refrain from distracting side conversations or speaking out when another person is talking. Audience members will refrain from shouting, booing, or any similar unruly behavior that impedes or disrupts the orderly conduct of the meeting. This morning, we have two bills on the agenda. We will hear House Bill 117 and House Bill 126. At this time, I would like to move House Bill 117. It's now on the table for consideration. The bill sponsor, Representative Lawley, if you'd come forward. Good morning. If you would state your name and your guest's name and walk us through the bill.
Thank you, Chairwoman Rodriguez-Williams. Again, good morning, Labor Health Committee. Good to see you, and I really appreciate the opportunity to present House Bill 117 to you. I'd like to walk through the bill, or before I walk through the bill, I'd like to give a little bit of background on the bill that I think will help us as we walk through. So with that, House Bill 117 empowers a woman, not the state, to enforce her own right to be fully informed and free from coercion. I want to repeat that. House Bill 117 empowers a woman, not the state, to enforce her own right to be fully informed and free from coercion. The bill does not mandate the state to take any action. Rather, it provides a private right of action for a woman who is harmed by the performance of an elective abortion against any person who performs the abortion in situations where the harm was due to negligent, reckless, or intentional conduct. Voluntary informed consent was not given, or the abortion provider knew or should have known that the interested party was coerced into the abortion. Committee, it is well settled law that adequate and legitimate informed consent is necessary for a woman considering an abortion. She cannot agree to medical intervention unless she is competent, adequately informed, and not coerced into giving her consent. The bill defines adequate informed consent and coercion for purposes of this cause of action. As you will see in the findings and hearing testimony today, many women are indeed coerced to having abortions. And there are many women that don't feel they fully understood what was happening when they chose to have an abortion. This is alarming, and it's a dangerous reality that we don't talk enough about. Women deserve the right to seek and recover damages from the person who performed the abortion in these circumstances that resulted in harm to the woman. That is what this bill will do. It is a tool for women to protect themselves. And with that, I'll walk through the bill, Madam Chairman.
Please, Representative.
Thank you. You see on page 2, there are 2 pages of legislative findings. There are 7 of them. You will be hearing testimony today to support these. Some of these are sort of self-proving in that they are decisions from courts that have looked at this issue of informed consent. And then we'll go through to page 4. And what we have here is if you wanted kind of an outline of the purpose of the bill, you will find it on page 4, lines 1 through 11. And then on page 4, line 16, we begin with some pages of definitions. And you can see those. I know we've already had an introduction on this bill, so many of you have already read it and are aware, but there are definitions then that go through page 15. And then on page 16, you'll find one other definition at the top, but then we move into this right to a private cause of action on page 16, beginning at line 6. And you will see in lines 9 through 12 that any interested party may bring a civil action against any person who performs an elective abortion where the interested party was harmed by the performance of an elective abortion and the pregnant woman. And then there are 3 situations listed there. You could have one, or you could have all 3 as a basis of the cause of action. And they're what I mentioned in the introduction as well. So on page 17, you will see upon prevailing in an action, there's some statutory damages of $25,000 for each claim. And then there's additional compensation that could be awarded by the court based on the facts of the case and the findings of the trier of fact. And then you have some other provisions at the bottom of 17 that have to do with some, like if you pursue something under this action and you get a recovery of statutory damages, you kind of can't come back again for a second bite at the apple, which is kind of a known principle in the law that you can't do that. Then you'll see on page 18, I'll just highlight the statute of limitations. It's 5 years, and we can talk a little bit about why. But the 2 main reasons I would point you to is that sometimes the effects of an abortion can come several years later when a woman, for example, might try to have a child. And we're going to have some testimony on that today. And also in cases of coercion, sometimes it takes a woman that has been in that kind of abusive, coercive situation to have some time to kind of either break free from that relationship or just feel she can begin to process what happened and then pursue an action against that person. So that is why there's a little bit more time in that statute of limitations. As we get to page 19, what you'll see is some legal language about, for example, the First Amendment. Nothing in here is intended to or construed to be basically be any sort of restraint on speech. And let's see, let's move over to page 20 and talk about this right of intervention. What we've done here is one of the things that was very clear in the last Supreme Court decision on the issue concerning abortion was the idea that, the state didn't do this, the state didn't do that. And so out of concern for that, I felt like that we should address the issue of a right to intervention, but it has some protections in it. It has to be a joint resolution passed by both chambers, 2/3 vote to appoint a person or persons to represent the legislature. And so I think that we've kind of struck a balance here, but I will say that the idea that the legislature can in any way interact with the court is not really that strong of a separation of powers argument, because we actually have to interact. And to say we'll go to court and advocate for what we've passed is not really a separation of the powers. The court can do what it will with that intervention, with that when they hear that testimony. But I believe that this is important, and I point this out too. The intervention right only arises if there is a constitutional issue. It's not just anything we do that we want to support with some other challenge, but constitutional challenges are unique. And they have some unique components to them. And so I really feel that this is an important provision to add. And then there is on page 21, two things I would point out. One is, of course, the effective date, but then this idea we're bringing in also healthcare workers that would work in settings where they're contracting with government agencies and things, that this would be bringing in this statute, this saying that it will in effect create a kind of negligence if they don't do the things in here in this statute. So to make sure that we're covered with any woman who got an abortion in a public or a government operated facility. So, and then as I said, there's the effective date of July 1st, 2026. And with that, Madam Chairman, I'd like to introduce Brad Kerr. He is with Americans United for Life. He and I collaborated on this bill, and I know there's been some questions about First Amendment, et cetera. And so I just would like to give him a chance to make some comments and answer. He will answer some questions too as they come up.
Thank you. If you'd repeat your name and anything you'd like to add on the bill.
Thank you, Chairwoman Rodriguez Williams. My name is Brad Kerr. I'm with Americans United for Life, and I appreciate the opportunity to address this committee. As Representative Lawley has laid out the provisions of this proposed legislation, a couple of the things that have come forward in regards to the constitutionality of this. One is, excuse me. One is actually a question of compelled speech on whether or not this is forcing a physician to say something that is against their opinion. And in fact, this has been well litigated. Even one of the clearest cases on that is Planned Parenthood v. Casey that the judgment was handed down in 1992 that said that statements that occur within the course of the practice, basically the course of the practice of medicine in relation to the procedure that are occurring, are not compelled speech. In fact, they are part and parcel of practicing medicine. And what the court said is that they are incidental to the regulation of speech. Therefore, in that case, the state of Pennsylvania was able to require informed consent of a woman who was seeking abortion, very similar to this bill here. So that's been well litigated. In addition, the more recent case, Javier Becerra v. NIFLA, just a few years ago, asked the question on whether or not a pro-life pregnancy center could be forced to refer for or post information about abortion. Now, the court viewed that differently than informed consent because it was taking into consideration whether or not the pregnancy center was required to say something that was against their mission, as opposed to the actual practice of medicine. What is included in here, if you look at the definition, is the elements of informed consent include the potential consequences of a procedure that is occurring. That's standard practice within medicine. It also includes a statement of what procedure is going to be used and how that procedure is going to occur. On top of that, it also requires that, or it also considers that the woman know the possible outcomes, the possible consequences of what she is deciding to do. So this is not compelled speech, and that has been well litigated throughout the years, dating back to 1992. And even the Becerra v. NIFLA case distinguished the requirement of informed consent and a forced requirement to say something about abortion. So this clearly falls within the Planned Parenthood v. Casey paradigm and jurisprudence of the court. On top of that, I know that there was a question about the standard for understanding coercion. What is included in here is a reasonable person standard. And that's not a subjective standard, meaning it's based on, some nebulous idea. The court has always viewed that as an objective standard. What would a reasonable person do given the information in front of them in regards to the circumstances and the elements that they see. That's an objective standard that has been utilized by plaintiffs' attorneys for over a couple hundred years at this point. It's actually rooted in British common law that has been brought into the American legal system. So that is a clear standard that is known by the courts and is known by lawyers throughout the nation. Additionally, one of the things I want to note here is that when we talk about coercion, we're actually talking about a majority of the women that receive or pursue an abortion. Statistics actually show, there was a 2017 study that was done in regard to women's abortions experiences. 73.8% of women said that they disagreed with their decision to abort, that their decision to abort was entirely free from even subtle pressure from others to abort, meaning that had they had a conversation about coercion, then they may have had an entirely different understanding of their approach. Now, they may have made the same decision, but they would have done it on different grounds. And that's the point of what we're doing here, is to make sure that a woman has the tools that she needs to exercise what the Wyoming Supreme Court has said is her healthcare decision. Now, I'm not going to talk about whether or not the court decision was appropriate, but this bill is responsive to that and recognizing the need for a woman to have those tools to vindicate her own ability to make a decision. Like I said, informed consent is making sure that she has the information necessary to make a decision about a procedure that she is about to undergo. And based on the jurisprudence of not only the US Supreme Court, but courts across the nation, this falls squarely within the ability of this state to accomplish constitutionally. And I'll make one more comment here on the ability of the legislature to vindicate its own rights before the court. If we go back actually to the beginning of Supreme Court jurisprudence, the Marbury v. Madison case, the claim wasn't that the Supreme Court takes supremacy over the executive branch or the legislative branch. It was actually that the Supreme Court have equality with the executive branch and with the legislative branch. A right of intervention here is making the same claim that the court made in Marbury v. Madison, stating that the legislature has the ability to vindicate itself in its decisions before the court. It's not taking away the ability of the court to make decisions on that. It's simply saying that the legislature has the opportunity to bring its opinion to the court. Additionally, the executive branch, which the Attorney General is part of, has the same right and the same ability. So in a way, making a statement that there's an intervention available to the legislature is stating that the legislature has an equality in the ability to vindicate its actions before the court and alongside the executive branch. So this is a statement of equality. So I will leave it at that as far as background. Thank you.
Thank you, Representative Mr. Kerr. Committee, any questions on the bill draft? Representative Yin.
Madam Chairman, thank you. So lots of thoughts on all of those things. Thank you for presenting the bill, Representative Lowey and Mr. Kerr. You know, the legislature always has the final word, frankly, because we're the only ones that can refer constitutional amendments. The judicial system can't do that. I'm concerned about us empowering a specific subset of legislators, not just the legislature. We're empowering a specific subset of legislators. Only the ones that are on this list on the front page can be interveners. And, you know, I think we talk about findings all the time, but I did look up the two studies that you put, because I think if the legislature is going to say the legislature finds that these things are true because of these studies, it's important for us to know what's in those studies. So Mr. Kerr quoted one of them, which is the women who suffered emotionally from abortion study, the Coleman study. that study and the Reardon study, both of them are online surveys. So basically the same as my radio station that surveys, or the newspaper here that surveys. It's got more people, I granted that. So one had 1,000 and the other had 200. But the Coleman study, and I would like you to talk about this, the Coleman study was specifically an online survey that only reached out to these pregnancy centers and had those pregnancy centers reach out to women that they counseled. So you have a specific demographic of women that only the pregnancy centers basically picked out to ask them to answer the survey. So I think it's hard for me to say that this finding is true because of the survey when the only people that were picked out for the survey are people that pregnancy centers picked out for them. And the second one, we're talking about the 60%, the Reardon study. Again, it's by a marketing firm, and this is all in the study itself. They quote their methods, which is great. They pay women to take small surveys, and so you get $1 to $3 a survey. So again, you get a specific demographic of people who are taking these surveys for money, which is probably why financial pressure is that highest pressure in their survey. And so I am curious on whether you found any studies that give a broader, more representative sample of women who have abortions rather than these two specific studies that limit the kind of demographics they chose.
Thank you, Representative Yen. Mr. Kerr on the findings.
Thank you, Chairman, and thank you for the question. So as I understand it, the question isn't so much whether or not coercion occurs, it's a question of the methodology. Am I correct?
Representative Yen.
Mr. Chairman, it's whether the legislature should agree.
Representative Yen. Madam
Chairman,
Thank
sorry,
you.
apologies. Madam Chairman, it's a question of whether we should put in findings, studies that are frankly not up to muster to list as findings that we're making policy around. I think it's fine for the legislature to make policy based on whatever they want, but I think if we're going to put findings in and we're going to put studies that we base those findings on in the statute book, they should be more rigorous than what we have currently in this bill.
Mr. Kerr, if you'd like to respond.
Thank you, Madam Chairman. Appreciate that. One of the questions that has always been out there is the reporting requirements in relation to abortion. And the fact that an individual is willing to ask the question about coercion is a valuable question. It's a legitimate question and is something that absolutely needs to be addressed. A 2014 study actually found that out of trafficked women, that a majority of them actually showed that they experienced a significant level of coercion. And let me pull the name of that study.
Madam Chairman, while he pulls it up, just a question.
Are you ready, Mr. Kerr?
I am, yes.
Please proceed.
And that was a study by Laura Lederer and Christopher Wetzel called The Health Consequences of Sex Trafficking and Their Implications for Identifying Victims in Health Care Facilities. And let me give you the reference point for that. That's 23 Annals Health 6131, published in 2014. And that 2014 study on health consequences of sex trafficking victims found that 66 sex trafficking victims had a total of 114 abortions, without counting for possible underreporting. The sex trafficking survivors in the study reported that they often did not freely choose the abortions they had while being trafficked. A majority of the 66 sex trafficking victims indicated that one or more of their abortions was at least partly forced upon them. So different studies definitely use different methodologies, and the information made available through those studies is made available to this legislature.
Madam Chairman.
Committee, further questions of the bill sponsor? Representative Clouston.
Thank you, Madam Chair, and thank you both for being here. Just following up on Representative Yin's question, if we remove the two studies on page 3, does that actually hurt the bill not to have these in statute?
Representative Lawley or Mr. Kerr?
Well, Madam Chairwoman, Representative Carlson, thanks for the question. We could do that, and I don't know that it hurts the bill. But I might suggest a substitution, and especially let's wait till we hear some testimony. I, for one, can talk to you a lot about women that I have worked with who've had abortions, who did feel they weren't informed, they didn't understand, and who were coerced or felt they were coerced, and there were different types of coercion. But so I think you're going to hear some testimony. So the question becomes, is it the study itself or the idea that that's right and correct, that women are coerced, and that's not a good thing. We don't want that. They can't give the kind of consent that legally is required when they're under coercion. So maybe if we were to do that, we would substitute a statement about the coercion happens.
Further questions, committee of the bill sponsor, Representative Clouston.
Thank you, Madam Chair. Again, I always have a separation of powers issue when we are going to try to insert legislative opinions during the court. You know, we have the Attorney General's office that have their duties. We have our duties to write the law. Do you see any conflict when we have the legislature involved with the Attorney General's office? What happens if there's a little bit of a differing approach or opinion during that court case?
Representative Lawley, if you'd like to elaborate from your original statement on that.
Yeah, I thank you, Madam Chairwoman. I think we've covered that that is not, again, there's a role for the legislature to defend what it's done. And the role of the Attorney General is actually to defend what we've done as well. So just because we intervene doesn't mean we're going to have a different point of view. It's just that we are going to be able to express our basis of that point of view more clearly from regarding what the legislature intended to do and defend that. And again, I just point back to the recent decision that criticized the state's work in doing that through the Attorney General, not specifically or by name, but I'm just saying that that was a repeated statement within that opinion.
Additional questions from the committee of the bill sponsor? Okay, seeing none, thank you both. Don't go far. Are there any government agencies that would like to come forward on House Bill 117 or join us online? Mr. Caldwell, is there any? I didn't see anybody signed up from any government. Thank you, sir. Okay, we will actually, by a show of hands, I know how many we have that want to testify online. If you plan on testifying on House Bill 117, please raise your hand. Keep them up. 2, 3, 4, 6, 7, 8, 9. It looks like we have 9 or 10. Okay, so we've got a total of 16 that want to testify. Obviously, we have 2 bills to cover. If we don't finish both of these bills, we will reconvene after adjournment today to finish these. This is the last week to get bills out of committee. Okay, so I'm going to limit time to those that want to testify on this bill. We have 3 chairs up here. We're going to move quick, so fill them up. And then after we take in-person testimony, we will move to online testimony. You'll have 2 minutes. I would encourage you to be succinct and not repeat anything that we haven't already heard. Bring something new to the committee. So come on up if you're planning on testifying. I've got a timer. Good morning. If you'd please state your name and we'll hear your testimony on House Bill 117.
Good morning, Madam Chair, members of the committee. Wendy Volk from Cheyenne. I'm a private citizen, speaking as a wife, a mother, and a local business person. Every medical decision I have made in my life has been private, personal, and with informed consent. Let me begin clearly. Coercion is wrong. Negligence is wrong. Women deserve informed consent. If any physician pressures a woman or fails to meet medical standards, they should be held accountable. This is not in dispute. What is at issue is how we legislate after the Wyoming Supreme Court's decision in State versus Johnson. In that case, Our court held that the Healthcare Freedom Amendment protects a fundamental individual's right to make one's own healthcare decisions. The court explicitly determined that abortion qualifies as healthcare under the Wyoming Constitution and applied strict scrutiny. This is now binding law in Wyoming. HB 117 does not simply reinforce informed consent. It creates an abortion-specific civil liability structure. Minimum statutory damages of $25,000 per claim, mandatory attorney fees for plaintiffs, no attorney fee recovery for prevailing defendants, restricted defenses, and a 5-year statute of limitations. These are not standard malpractice law. If the goal is simply coercion, coercion is already illegal. If a goal is stopping negligence, malpractice law already applies. If the goal is strengthening informed consent, that can be done neutrally across medical practice. But when we single out one form of constitutionally protected healthcare and layer punitive civil exposure onto it, courts will evaluate that as a potential burden on a fundamental right. Strict scrutiny does not require an outright ban. It applies to substantial burdens. A liability framework designed to deter providers can qualify. You may disagree with the court's ruling. This is
We're out
understandable.
of time. Thank you for your testimony.
I'll-
Committee,
thank-
any questions of Ms. Volk? Okay, seeing none, thank you for joining us this morning. Ma'am, please state your name and we'll hear your testimony.
Thank you, Madam Chairman. Kathy Russell, Executive Director of the Wyoming Republican Party. This has long been a primary priority for the Wyoming Republican Party, the protection of life and the protection of individual rights. This bill addresses that. The question of the validity of the studies may be a distractor and a diversion because the issue is informed consent. Personal experience tells me that even in lesser situations, I have not been afforded informed consent. The most recent was being diagnosed with something, and I was given a prescription for a medication that was directly in conflict and would harm me. So the informed consent didn't happen. And something as serious as this, it's even more critical. And coercion does happen. Anybody who is a woman who knows other women knows that that happens. So the studies cited, if other studies are used, that's fine, but they established the intent of the lawmakers. Furthermore, state court case establishing healthcare, the implication has been that our law and the implementation and the execution of it have been perfect. This bill addresses some things that are not perfect. We do need this to protect women and to reinforce this issue, which is one of the purposes of law. Thank you, Madam Chairman.
Thank you, Ms. Russell. Committee, any questions? Representative Yen.
Madam Chairman, thank you. Ms. Russell, in that situation where you feel like you didn't get informed consent, did you take it to court?
No.
Ms. Russell?
Madam Chairman, no.
Thank you, ma'am, for joining us. Sir, please state your name and we'll hear your testimony.
Thank you, Madam Chairman. Gary Brown, House District 41. I'm going to tell you, first of all, I support both these bills in the interest of time. In 2021, I met a beautiful young woman. We had a relationship for about 3 years. And I learned very quickly that she had some real problems. She was diagnosed manic depressant. And as our relationship went on, I found out that when she was 17, that she got pregnant. Her parents took her to get an abortion. At that time, the stigmatism of having a child out of wedlock was really a great thing. And so she suffered for many years because she didn't want the abortion. She at times became violent. Every year during that time when she had had that abortion, she would take to her bed and she would be in bed for over a week. And just she suffered really desperately over this. I was informed this weekend that in August of 2023, she took her life. And in the note that she left, she never forgave herself for standing up and going against her parents and having the abortion. I just found it ironic that I just found this out. Thank you.
Thank you, Representative Brown, for sharing that. Committee, any questions of Representative Brown? Thank you, sir. Fill the chairs if you plan on testifying, please. Sir, please state your name and we'll hear your testimony.
Good morning, Madam Chairman, members of the committee. My name is Greg Hunter from Laramie, Wyoming. I just want to say this legislation is an example of how the quest to overturn Roe has resulted in electing legislators that will traffic in junk science and conspiracy theories to design laws that are destroying our republic. The very idea that a neighbor has the right to manage another neighbor's womb is a corruption of our Constitution and our Bill of Rights, and does not pass the smell test from a reasonable person. This ridiculous quest by unreasonable people has resulted in the worst Supreme Court justices in our history. And as the GOP restricted their selection of justices to ones that would decide that the power of the state should be used to fulfill unconstitutional desires to manage a citizen's womb. We have degraded as a nation since the right to lifers took up their cause. We hold these truths to be self-evident. Thank you, and I'll stand for questions.
Thank you. Any questions of Mr. Hunter? Seeing none, thank you, sir, for your testimony. Sir, please state your name and we'll hear your testimony.
Thank you, Madam Chairman. Members of the committee, my name is Michael Lehman, representing the Catholic Diocese of Cheyenne. Probably every single one of us knows a family member or friend, a loved one who's had an abortion. And we know that all abortion stories are not the same. Many stories are not reflected by the mantra of choice, which we are so often called to focus our attention on when considering this subject. As mentioned, there are many studies that highlight that many women did not have an abortion they wanted or were coerced. Many of these women were born and raised in a society that has been diligently attempting to destigmatize abortion. And a society that destigmatizes abortion creates an environment whereby any new mother who's not in an ideal situation will find that abortion is not so much a choice, but an expectation from her boyfriend, her husband, her parents or siblings, even her employer. All the while, the state has stood by and washed its hands of any responsibility for protecting the life of her unborn child or protecting her from coercion. This bill isn't asking much of the state. It's simply creating a path forward for any woman in the future who finds herself being pressured into having an abortion, to know her situation is not unique and to know she has some legal protection. Madam Chairman, members of the committee, there's nothing radical or extreme about wanting to protect mothers and their vulnerable children. With that, I would stand for any questions.
Thank you, sir. Committee, any questions of Mr. Lehman? Seeing none, thank you for joining us.
Thank you.
Ma'am, please state your name and we'll hear your testimony.
Thank you, Madam Chairman, representatives. My name is Britt Borrell. I'm Executive Director for WYO United. We are a nonpartisan advocacy group that's focused on advocating for reproductive freedom and expanding reproductive health care in Wyoming. Contrary to its title, I find this bill to be incredibly offensive and disempowering to women. It's also unnecessary, as doctors already obtain informed consent from patients. If that is inadequate, as some have noted here today, then that should be extended to all of healthcare. This bill seeks to insert the legislature into the doctor-patient relationship and treats women as if they cannot be relied upon to make their own medical decisions. As we've already stated, the studies cited in this bill to support the claim that the majority of women are coerced into seeking an abortion are flawed. This bill cited that 2023 study that implies because 60% of women experience high levels of pressure when seeking abortion care, they must be coerced. However, the highest external pressure reported in that report was financial, not partner coercion. So really, this study shows us that providing an economic safety net for women would likely prevent abortion. I also think it's interesting that there's no mention of forced pregnancy and coerced pregnancy in harmful and abusive relationships, which is actually one of the most common types of coercion that I see occur here. The penalties for healthcare providers are also egregious and unreasonable in this bill. Harm is defined so broadly here that it would likely deter OBGYNs from practicing in the state. The bill says that if a provider should have known of coercion, they can seek damages of at least $25,000. Surely, if coercion was present, damages should be sought against the person who coerced, not the care provider. No one is implying that the decision to seek an abortion is easy or free from external or internalized pressures. I don't know a single woman who has entered this decision lightly, but they all weighed the alternatives for themselves and made the decision that was best for them and their unique circumstances. Wyoming women deserve to be treated with dignity and respect by our government, not constantly confronted with barriers to care out of some misguided paternalism from lawmakers who do not think we are capable of making informed decisions. Please vote no on this bill.
Thank you. Any questions of Ms. Worrell? Seeing none, thank you for joining us. Sir, please state your name and we'll hear your testimony.
Thank you, Madam Chair. I'm Dr. David Lind. I'm a private citizen, now retired from practice of obstetrics and gynecology. I practiced in the state for over 35 years. I'm a Cheyenne native, born and raised here. I think that one of the most foundational issues in the practice of medicine is informed consent. If we're concerned at all about the quality of care that we provide for women, and if we really want women to get a good quality care, there has to be adequate and informed consent. The consent process allows a woman to know the crucial details of the action that she's considering. It creates standards or safeguards to allow the woman to have accurate descriptions of the proposed procedures, outcomes, complications, et cetera. And most importantly, the informed consent process allows the establishment of a doctor-patient relationship so that the patient has an idea who they're going to call should a complication actually arise. I think those are foundational to this bill. The types of procedures have different kinds of complications. And when we're talking about abortion, there's differences, whether it's surgical or medical. And there's differences as to the gestational age of the abortion being proposed. Surgical abortions are much more risky as you get further into the pregnancy and carry with them higher complications and more serious things. Medical complications can arise based upon the type of medication that's being provided and the gestation of the pregnancy as well. With adequate informed consent, the types of treatment needs to be specified along with the complications, which may include the failure of the treatment to terminate the pregnancy. It could cause hemorrhage, infection, possibly leading to sepsis and even death. Uterine perforation and damage to adjacent structures can happen when we're talking about surgical procedures. Adequate informed consent also requires a description regarding alternatives to treatment. And that's something that's not talked about a lot. But one of the things that happens in an adequate informed consent process is to discuss what happens if we don't do this procedure.
Dr. Lind, you are out of time.
I'm sorry. Thank you, Madam
Yeah.
Chair.
Committee, any questions of Dr. Lind? Representative Yen.
Madam Chairman, thank you. Dr. Lind, so penalties generally affect how malpractice insurance is assessed. Do you think that a $25,000 penalty is appropriate for informed consent violation?
Dr. Lind.
Thank you, Madam Chair. Representative Yen, a $25,000 fine is negligible in obstetrics. Most of the cases that prevail settle for much more. So I don't think that that's an impediment at all to this bill.
Committee, any further questions of Dr. Lind? I have one, please.
Yes, ma'am.
When it comes to informed consent, Dr. Lind, regarding fetal surgery, which technology has come a long way over the years, parents they receive lots of detailed information before that surgery takes place. Essentially, that baby in the womb is a second patient. The mom will often have her own physician, and then the baby that's going to undergo surgery has their own physician as well. Talk to me a little bit about your thoughts when it comes to informed consent and the fact that in Wyoming right now, surgical abortions are legal. So looking at this bill, just curious what your thoughts are.
Thank you, Madam Chair. I think that when we're looking at surgical abortions, there is such a wide variety of the way that they're going to be done, and it depends on the gestation. And truly, early gestations have much lesser risk than later gestations. There was a recent woman who died in Fort Collins in the last year from a 22-week abortion. Those things do happen. The interesting thing about fetal surgery is that the baby ends up being born twice. It's born once to be presented for the surgery, to be allowed to be operated on, and then it's put back in the womb and allowed to be carried to term and be born again. So that creates an entirely different spectrum of informed consent that has to be extremely detailed. And to gloss over the details of informed consent does not empower women or their spouses to be able to make accurate decisions. I hope that answers your question.
Thank you.
You're welcome.
Committee, any further questions of Dr. Lynn? Okay, seeing none, thank you for joining us.
Thank you, Madam Chair.
Sir, if you state your name and we'll hear your testimony.
Good morning, Madam Chairman, members of the committee. My name is Steve Milia, a private citizen here from Cheyenne, Wyoming. My background is in public health for the last 30 years. When I was in Houston, Texas, working for the City of Houston Health Department, I was trained by Planned Parenthood, worked with them, not for them. I worked for the City of Houston Health Department, and I gave a lot of presentations to students out there. And what I found was that Planned Parenthood in that particular area, they would talk about abortion, but they would say, well, it's a product of conception, it's pregnancy tissue, it's a collection of cells. They wouldn't really give the students, the boys and girls, exactly what abortion was, that it was a human being. They were trying to obscure the fact that we are talking about another person. And to have informed consent means that you need to tell them that that is a person. You have human sperm from the father, you have a human ovum from a woman. That is humanity. And then when the two combine together, that does not mean it's non-human. And they would try to get it across that, well, no, it's not really human, it's not really alive, it's just a collection of cells, et cetera. And so the students were sort of confused a little bit and think, oh, it's not really a person. We are talking about killing another person. Human sperm, human ovum, that's human. We are talking about killing your son, your daughter, another person. And so informed consent means knowing exactly what's going on. And I would have to correct a lot of misinformation when I gave hundreds of presentations over the 5 years that I was down there. And so informed consent is really necessary to find out what exactly abortion is and not to regret saying, oh, I didn't know that from the beginning. I wish I would. And a lot of students said, thank you very much for telling us exactly what abortion was, that it was human and that it is killing my son, it is killing my daughter. Informed consent means all the information, just not part of it. Thank you, ma'am. Stand for questions.
Thank you, sir. Committee, any questions of Mr. Milia? Seeing none, thank you, sir, for joining us. Ma'am, if you'd state your name and we will hear your testimony.
Thank you, Madam Chairman. My name is Maria Ward. I work for the Catholic Diocese of Cheyenne as the Project Rachel coordinator. Project Rachel Ministry is a national effort by the Catholic Church that started in the 80s in order to help women and men who are suffering in the aftermath of abortion. I help not just those who have experienced an abortion themselves, but grieving grandparents as well as surviving siblings who are struggling emotionally after having an abortion experience. So I come to you today to speak for those who do not feel comfortable sharing their abortion experience, but I have accompanied them on their long healing journey, which often involves trauma therapy, extensive counseling, things of this nature. Many of these people do not tell a lot of people about their abortion. This does hurt. The research that we have about those who are choosing abortion. It is very difficult for them. There was one person in particular that I was the very first person they had ever told about their abortion, despite their years of emotional turmoil over this decision. They did not feel that they knew truly what they were getting into. They were at such a high level of emotional distress. Their family was encouraging them to do this without fully understand. Their family wasn't coming to the appointments, so they did not have the information that was presented to them of what is needed for true informed consent here. So I come to you to share their stories. It is a very, very powerful bill that would help women make better choices about their abortions, to fully understand what is happening to them so that they do not live with years of regret. I've accompanied people who are on their hospice bed, and their abortion is the last thing that they feel like they need to work through to heal, to die in peace. I'd stand for questions, Madam Chairman.
Thank you, Ms. Ward. Committee, any questions of Ms. Ward? Okay, I have one.
Yes.
In your program, do you counsel men, and are men affected?
Yes, we do. We do. Most of the people we help are women. However, we do help men as well. Their grief is certainly very different, and often it manifests in different ways, typically more, in an anger type of way. But yes, we do counsel men. Their experiences are also very different of a man who knew that she was having an abortion and perhaps encouraged her to do that, versus we've also had men that grieved substantially because they did not know that they were a father, and she went and had an abortion without telling him, and he found out after the fact. So there was a piece of just not being involved in that decision, and that caused severe emotional distress.
Thank you. Okay, thank you for joining us. Ma'am, please state your name and we'll hear your testimony. And then we're
Yeah.
going to move to online. Thank you.
Madam Chairman, my name is Linda Burt, and I'm with Wyoming Right to Choose. I just have a few comments here. I don't think there's any indication, or no one has given any indication, that Wyoming medical providers do not give correct information, do not give appropriate information in terms of whatever the consent is. All these procedures have to have medical consent, informed medical consent. I do not believe it's up to the legislature to provide what that medical consent should be. I think it's up to the medical providers. They are the ones that have the information, the background, and the education to give the appropriate kind of consent. I don't think this is a necessary bill because I think it's an unwarranted intrusion into that relationship with medical providers. We don't need to compel their speech and tell them what to do in this instance. I think it's another barrier to abortion. I think it is inappropriate. I think it says to women and doctors both, you are not capable of making decisions on your own unless we direct you to those decisions. It also singles out one medical procedure for scrutiny and legislative involvement. The greatest harm to women is the risk of pregnancy. If we're going to tell women and doctors how to choose and what kind of consent to give, we should talk about the incredible harms about becoming pregnant, because the risk is very much higher in terms of infection, in terms of death, and in terms of just damage to women from pregnancy than there is to abortion. The American College of Obstetricians do not approve or support these bills on any level. The other thing that wasn't mentioned is that there is a 24-hour waiting period in this bill. That is not necessary. Women do not need to be singled out to tell them that they have to wait for a procedure that they have already made a confident decision about in this area. It is simply another barrier to abortion, and I would ask you to vote no on this bill.
Thank you. Committee,
Thank
any
you.
questions of Ms. Burt? Representative Heft.
Thank you, Madam Chair. Ms. Burt, did I hear you correctly saying that being pregnant is more hazardous to women than surgery?
Than having abortion, yes,
Ms.
sir.
Burt?
Oh, I'm sorry. Madam Chairman, Representative, yes, I did say that. It's more dangerous for a woman to be pregnant and carry out that pregnancy than it is to have an abortion. Yes, and I would be happy to provide you with those statistics.
Okay, thank you.
Any additional questions of Ms. Burt? Seeing none, thank you, ma'am, for joining us.
Thank you.
Sir, I will allow an exception. You're going to be the last one before we move to online testimony. So if you state your name and you have 2 minutes.
Work. Thank you. My name is Bruce Lynch, and I'm a citizen here in Cheyenne. And I thank you for the opportunity to give our testimony. And just a moment ago, you mentioned that the baby is treated as a patient, correct? That's what you just said about the baby being a patient as well as the woman. And that is a point that brings up, if you talk about consent and being informed, no one is informing the baby about what's going to happen and have their limbs removed in a very painful way, one by one. There's a person there that's not informed at all. You just said that. So I just wanted to point that one thing out. We're talking about consent and informed. There's a third person here that isn't informed at all. Thank you very much. I appreciate it. Is there any questions?
Thank you, Mr. Lynch.
Thank you.
Committee, any questions? Mr. Lynch? Seeing none. Thank you, sir, for joining us for your testimony. All right, we'll go ahead and move to online testimony. Again, we've got 6 folks, so please raise your hand and thank you for joining us. If you'd state your name and we'll hear your testimony for 2 minutes.
Hello, thank you, Madam Chairwoman and the committee members. My name is Katie Knetter, and I'm the Executive Director of Wellspring Health Access. We are the organization that operates the state's only procedural and medication abortion facility. I'm speaking today because we have grave concerns about this bill. As mentioned by only one other speaker, it does require a mandatory 24-hour waiting period after a person would receive this informed consent information before they could seek medical care. And that is something that is not required of any other medical procedure in the state. It is something that infantilizes and demeans women. We find that women are able to make their own decisions about their healthcare without governmental interference. And in fact, the Supreme Court found the same thing. And as far as informed consent goes, as other state speakers have already mentioned, this is also something that already happens in medical care. Physicians provide all of their patients with the appropriate materials to determine the risks and the benefits of any medical treatment they are receiving. And patients can seek damages through medical malpractice if they feel that their care was inappropriate or not the way it should have been in any way. And so this is not only unnecessary law, but it's unconstitutional. And we really feel like the legislature should have spent their time this session working on bills that actually increase access to abortion care, but also maternal care and also other types of reproductive health care. Thank you, and I stand for questions.
Thank you, Ms. Knetter. Committee, any questions? Ms. Knetter? Go ahead. Representative McCann.
Thank you, Madam Chairman, woman, sorry. Ma'am, I'm just wondering, how many patients do you have that you do informed consent on and do the procedure in the same day?
Ms. Knetter.
Thank you, Madam Chairman. I don't have that information directly in front of me at the moment, but all patients give their informed consent. They all meet with the physician. They all are provided with appropriate consent documents, depending on what type of procedure they are having. So they all do give consent the day they are having their procedure. So if that's what you're asking, then yes, they all give consent. If you're asking if they made the appointment the same day as their procedure, I don't have that information at this time.
Committee, any additional questions? Representative Washburger.
Thank you, Madam Chair. Yeah, thank you for coming and testifying today. I was just wondering if anyone has ever saw any damages there at Wellspring.
Ms. Canutter?
Madam Chairwoman, no.
Ms. Canutter, I have one question for you.
Absolutely.
Do you, in your intake form or in the informed consent documentation, have any questions that pertain to gestational carriers? So in other words, surrogacy.
Madam Chair, not to my knowledge. That is a situation we've never come across.
Thank you. And I just have a follow-up. In the event that there was a patient that came to your clinic and was a gestational carrier, and there was a contract that was already signed, is there any sort of informed consent that's provided to the intended parents?
Madam Chair, as that's not a situation we've dealt with, we probably would need to consult with our attorneys. But like I said, that's not a situation we've ever experienced.
Thank you. Any further questions, committee? Seeing none, thank you, ma'am, for joining us.
Thank you.
Move on to the next virtual testimony. Welcome, sir. If you'd state your name, we'll hear your testimony for 2 minutes.
Madam Chairman, can you hear me?
We can hear you.
Okay, my name is Ross Schriftman. I'm president of the Corona County chapter of Wyoming Right to Life. An abortion is a significant event for any woman who has had one or is considering having one. It is essential that every woman considering this life-changing event is properly informed of her rights. It has been mentioned of the studies in the findings of this legislation. We're very much in support of this bill. There are also many criminal cases of men abusing or even murdering women who decide they want to go through their pregnancy, and the abusive man does not. In addition, one of the important provisions in House Bill 117 is the requirement that women seeking abortions know who will be committing the abortion. In real medical care, we have the opportunity to know who will be treating us and be able to review reports and public comments about a doctor's training, expertise, and mannerism before we agree to receive his or her services. Too often, abortion businesses do not provide this information. Furthermore, it is unlikely the doctor performing an abortion is the woman's physical personal physician, and instead is someone who makes his or her money ending the life of a preborn baby. And we are much in support of this legislation, and we encourage the yes vote.
Thank you. Committee, any questions, Mr. Schiffman? Okay, seeing none, thank you, sir, for joining us.
Thank you.
We'll bring in the next testimony.
Next is Catherine Wheeler.
Ms. Wheeler?
Good morning, Madam Chair and members of the committee. I'm Catherine Wheeler, a board-certified OB-GYN. I practiced 24 years in Utah and now reside in Colorado. As part of my practice, I performed abortions and I testify on my own behalf. I want to thank the bill sponsors for this bill. Informed consent is a cornerstone of medicine for ethical care and shared decision-making. There is a real need for women to have all the information during informed consent. While some have said that this is already standard in medicine, it is not consistently applied. Policy does not mean practice. When medicine does not police itself, the law must step in to protect women. When they are harmed due to incomplete informed consent, their right for redress must also be protected as the sole responsibility of the clinician. That true informed consent is provided. The woman has all the information she needs to make that decision, that all of her questions are answered, that she understands the information and ramifications, and that she is signing voluntarily without coercion, duress, or intimidation. I hear consistently from women who've had abortions, they didn't tell me, I didn't know. What they told me wasn't what happened. Many tell stories of coercion or say, I just had no choice. My training and practice for informed consent for abortion was different than that which I provided for all other procedures. There were details I did not explain. I certainly did not explain the details about the baby, all under the guise it would be too hard for her. This is wrong. This is paternalism, withholding important factual information that could affect her decision. We know there's a power dynamic and perceived authority in medicine that women can already be put at disadvantage. Incomplete disclosures, especially egregious, and may be driven even by unconscious bias of the provider, thinking they know what's best for the woman without fully engaging her. Other abortionists, abortion workers, and women who have had abortions tell me that informed consent in abortion facilities is often done in a group setting, overseen by non-medical employees, not individually. She typically meets the abortionist the first time in the procedure room and often doesn't know the surgeon's name, training qualifications, or experience. Dr. Lind has already talked about the standards of informed consent. So in closing, I would say when a patient is given inadequate informed consent and is harmed, it is the state's duty to protect her. Abortion is a woman's choice only if she fully understands. Thank you, and I'm available.
Dr. Wheeler, thank you. Thank you for your testimony. Committee, any questions of Dr. Wheeler? Okay, seeing none, thank you for joining us this morning.
Thank you.
Sir, if you'd state your name and we'll hear your testimony. I can't read the name, Mr. Caldwell. My apologies.
Marcy Schaefer.
Oh, Ms. Shaver, please. We'll hear your testimony. You were on mute, so we'll go ahead and start the timer again. If you could state your name and we'll hear your, oh, we can't hear you. Oh. Ms. Shaver, we can see your lips moving, but we can't hear you. My apologies, we can't hear you. Is your volume turned up?
So all's good on my end.
And now we can hear you. Please state your name and we'll hear your testimony. We'll start.
All right. My name is Marcy Shaver from Torrington, Wyoming. I stand in opposition to this bill. It just seems like a slap in the face after the Supreme Court did agree that women are competent adults for making their own health decisions. It just, this just says you're not really competent. We have to double check you. It's, and the studies are blatantly biased when there are so many excellent studies out there showing that the regret rate for abortions is negligible. Women who make the decision to terminate an unwanted pregnancy are glad they did. And I'll let other people get going.
Thank you, committee. Any questions of Ms. Shaver? Okay, seeing none. Thank you for joining us. Anyone else with their hand raised, Mr. Caldwell?
Joanna Harder is next.
Okay, Ms. Harder.
Hi, I'm Joanna Harder. I'm in Lander, Wyoming, and I'm here speaking as a citizen today, not representing any organization. So this bill places new burdens and risks on physicians who are simply providing appropriate medical care. I think healthcare decisions belong between a patient and a qualified provider, not in this committee. Physicians already follow standards for informed consent and ethical care. Creating additional legal exposure and punitive consequences can intimidate providers and interfere with the care that patients are seeking. And maybe I suppose that's one intention of this bill. Pregnancy is deeply complex and deeply personal. It always involves a woman's body and another life developing within it. Women put our health and our lives on the line to bring children into this world. Many women who seek abortions are already mothers. We understand pregnancy. We understand the risks. We understand the gravity of these decisions. We are not uninformed. We are not careless. I am the person most qualified to make decisions about my body in consultation with my healthcare provider, not any politician. I respect the experiences of women who have had abortions and regretted them or felt coerced. Coercion should never happen. If coercion is the concern, punish the person who coerces, not the medical professional delivering lawful health care. I personally know several women who have had abortions, and none of them regret their decision, and they all felt they had informed consent. And at a time when Wyoming already struggles to recruit and retain healthcare providers, this is the message that we want to send with these kinds of bills, that political opinion outweighs medical training and patient care, that we are supporting legislation about medical care with flawed studies, that we are trying to create more risk for healthcare providers interested in practicing in our state. If we truly believe in local control and individual liberty, then the most local and personal decision of all is the one made by an individual about her own body with her medical provider. I'm asking that you please do not create more barriers within this relationship and don't overstep your role as politicians. Please vote no on HB 117.
Committee, any questions of Ms. Harden? Okay, seeing none. Thank you for joining us this morning. Any other hands?
Madam Chairman, last is Megan Colley.
Okay, Ms. Colley?
Hi, I'm Megan Coley, coming as a citizen as well, not representing an organization. Thank you for the opportunity to speak. Coercion is wrong, and issues with coercion and neglect are already illegal. The position of the current legislature isn't important in this. There's already recourse for women who have had harm. Meanwhile, women in our lives need to make their healthcare decisions, even hard ones, even sad ones. Women make decisions to protect their lives and the lives of their current and future family. Women don't take these lightly. Women are not confused by the outcomes of pregnancy. Women need doctors who are not operating in fear and can practice ethical, well-informed medical care. And my own sister would have been trapped in an abusive relationship rather than freed from one had she not been able to terminate a pregnancy. 2 others in my life had life-saving abortions. These were awful decisions to make, and they had trusted healthcare providers who were basing their decisions on medical standards. Again, no woman misunderstands pregnancy. If coercion is common in abortion, then we have larger issues that should be addressed across the medical field. Do not single out women and women's health care. Please vote no on this bill.
Thank you, Ms. Coley. Committee, any questions? Seeing none, thank you for joining us. And that's our last person online. Okay, I will close public comment. Committee, what is your pleasure?
Second.
The bill has been moved by Representative Guggemos, second by Representative Wasserberger. Let's work the bill and any amendments, discussion.
Madam Chairman.
Representative Ian.
Madam Chairman, I think that both studies are inappropriate. I'm going to move to remove both of them. I'll keep that finding line on page 3, line 6, but everything after the word abortions period until line 21 on page 3. So page 3, line 7, starting with a 2017 study and ending on line 21, strike all that language. That's my motion.
Is there a second?
Second.
Okay, we have an amendment that's been moved. Mr. Caldwell, do you have that? So we've got page 3, line 7, starting with the letter A and all the way down to line 21 to delete, correct, Mr. Representative Ian?
Yes.
Okay. All right, discussion on the amendment. Representative Heft.
Thank you, Madam Chairwoman. I did a quick check online and there's literally dozens of studies. I realize that these are only two, but I think that it's just representative of a larger question out there on coercion. So to delete these two, I don't think that's really a responsible thing to do, in my opinion.
Further discussion on the amendment. Representative Yin.
Madam Chairman, thank you. So put better studies in the findings. Don't, I mean, we're putting this in the green books to say that we as the legislature believe that these studies particularly reinforce the findings that we are making. If you want these to be the studies that say this is why we should do it, I mean, I think that's the legislative prerogative, but I would say find something more rigorous to put in there than these two.
Further discussion on the amendment. Seeing none, sensing the urge to vote by a voice vote and a show of hands, all those in favor of Representative Yin's amendment, state aye.
Aye.
All opposed? No. Okay, that amendment has failed. Further amendments, further discussion on the bill. Representative Yin.
Madam Chairman, so members, page 16. I'll give you guys a second till I don't hear page turning anymore. Madam Chairman, page 16, line 19, I move to strike or should have known. So we have these three parts. I'll explain it more if I get a second.
Is there a second?
I'll second.
Okay, the amendment, we have a motion to amend by Representative Yin on page 16, line 19, to remove or should have known. Mr. Caldwell, do you have that? Okay, discussion on the amendment.
Madam Chairman.
Representative Yin.
Madam Chairman, so we have this section that says any interested party can bring a civil action against any person who performs an abortion if they meet any of these three criteria. So it's an or. This one about coerced or forced into an elective abortion and the person who performed the elective abortion knew or should have known of the coercion. There's no way, I mean, who decides or should have known? Can anyone bring a case saying they should have known? And how would they should have known? We don't have any definition of how to determine whether someone who performs an abortion should have known. So I understand that new part, I'm keeping that there, but I don't understand how we enforced or should have known.
Further discussion on the amendment. Representative Clauston.
Thank you, Madam Chair. If acceptable, I'd like to hear the bringer of the bill's reasons why that should be in there.
Representative Lawley, if you'd come up. Thank you. On the term or should have known.
Yes, thank you for the question. This is a common way in the law of the courts deciding whether someone knew about something or should have known. And they use, again, a reasonable person standard. What would a reasonable person do, or in this case, a reasonable healthcare provider do in a certain fact situation? And this would be a matter of something that would have to be proved. They either knew or they should have known. So what would should have known kind of look like? It would look like someone coming in with their partner, maybe the father, maybe not the father, but comes in and that partner speaks for them. They recognize signs of distress in the woman that might cause them to further look into it by asking to speak to the woman alone or do some things to determine as best they can. It might liken it to what we see a lot in human trafficking, where people are being trained now to kind of, they don't know for sure, but they do sense something's off and that there's some sense of pressure that this woman in the case of abortion does not feel as if there's a sense that she doesn't necessarily want this, that she's being pressured. And so that would kind of fall under, they should have known, but again, it would be a matter of facts that are proved that those facts exist, and the court would decide, or other trier fact, a jury, for example, that yes, in those circumstances, a reasonable doctor should have known that she was being coerced.
Thank you. Committee further, go ahead, Representative Clauston.
Thank you, Madam Chair, and Representative Lawley. Thank you for bringing this. I just have one probably simple and I hope friendly amendment. On page 3, when we're looking at the two. Oh, sorry. Does he?
Oh, sorry, I didn't have my mic on. We have a motion on an amendment, so we're going to continue to work the amendment on page 16, line 19. Any further discussion on the amendment? Okay, seeing none, sensing the urge to vote. All those in favor of Representative Yin's motion or amendment, by a show of hands and a voice vote, please state aye.
Aye.
All opposed?
No.
Okay, that amendment has failed. Further amendments, Representative Clouston.
Thank you, Madam Chair. My apologies. So I'm going to bring an amendment, hopefully a friendly amendment, page 3, line 7. The word study after 2017, I'd like to change that to a review. So it'd read a 2017 review on women's abortion experiences. And I bring that because I don't think this meets the rigor of a study. It's more of a selective narrative that was looked at. So I think saying this is a study has a little bit of a problem in the bill. So again, the amendment is to change study to review.
Okay, is there a second?
Second.
We have an amendment on page 3, line 7, change the word study to review. Mr. Caldwell, you have that? Okay, discussion on the amendment.
This is Madam Chairman.
Representative Thayer.
Thank you, Madam Chair. Does the bringer of this amendment also then on line 16 want to do a friendly amendment with the word study also in that one?
Representative Clouston.
Thank you, Madam Chair, and thank you, Representative Thayer. You know, looking at the two that are cited, the second one probably actually does really qualify as a study. The first one, I would say not. So that's why I made that a specific amendment.
Further discussion on the amendment. Representative Lawley, if you have anything on that. Okay. Any further discussion on Representative Clouston's amendment? Okay, seeing none, sensing the urge to vote by a show of hands and a voice vote, all those in favor of Representative Clouston's amendment, please state aye.
Aye.
All opposed?
No.
No. Okay, hands up, hold on. If you oppose, keep your hands up. 1, 2, 3, 4. Okay, that amendment has passed. Mr. Caldwell, you have that? Further amendments, further discussion on the bill.
Madam Chair.
Representative Thayer.
Yeah, on page 14, the 24 hours, page 14, lines 8 to 13. I'm just concerned that we do not, we're carving out and there are not any other procedures that have a 24-hour wait. So I would ask that we would stricken lines, or if there's a, stricken lines 8 through 13.
Is there a second? Okay. We have an amendment on page 14, lines 8 through 13 to strike that language. Representative Caldwell has that. Discussion on the amendment. Vice Chair Ottman.
Thank you, Madam Chairman. I guess just to clarify that in my mind, not later than 24 hours before the performance or induction. The drug itself has time limits on it. Is that correct?
Vice Chair Ottman, you can direct your
Oh, I'm
question to
sorry.
the bill sponsor if you'd like, or the carrier of the
Madam
amendment.
Chairman, yes.
Vice Chair Ottman.
Yes, thank you, Madam Chairman. On page 14C, what is the reason to have the 24 hours? Would you explain that?
Representative Lawley.
And thank you, Representative Ottman. The reason for that 24 hours is time for a woman to digest the information they've been given and weigh the potential risks and et cetera, and then they would have the next day. I don't think it's right to say no other procedures. Do we do that? I've talked to doctors where there are procedures sometimes that they do that on. So we can get some testimony on that. But also, I want to point out this. So I urge absolutely do not vote for this amendment. And one of the reasons isn't just the 24 hours. It basically cuts out the part that says there's a required consent at all. So it's an integral part of the bill, whether you agree with the 24 hours or not. This amendment is damaging to the bill in significant ways, but I do support the 24-hour. And, you know, again, I just, it's not burdensome. It is giving that woman a chance to consider. And one of the things that's exempted from this bill is emergency situations. So keep that in mind. We're not talking about emergent, we're talking about an elective procedure. And I think the 24 hours is important because there are a lot of things for a woman to consider. This, as we have heard time and again through the testimony today, a consequential decision that can have lifelong effects on that woman. And we know that what the decision does to the unborn child. So I'm just saying that really isn't burdensome in my view. And I think it is supported with the evidence of that informed consent, having that information and being able to come back the next day. And so again, I strongly urge the committee to reject this amendment.
Thank you, Representative Lawley. Further discussion on the amendment? Question being called on the amendment. All those in support of Representative Thayer's amendment by a voice vote and a show of hands, please state aye. Aye. All opposed? No. Okay, further amendments, further discussion on the bill. Representative Gugamas.
Thank you, Madam Chair. I stand in support of this bill. Honestly, I don't think it should be necessary, but in the days we live, it has become necessary to have this kind of safety net. You know, doctors all take the Hippocratic oath. I guess the way I viewed it, it has become more of a hypocritic oath for some, just because they are doing harm to a living being, a living human being. So I believe that is my stance on this bill. Is why I support it. Thank you.
Thank you. Further discussion on the bill. Representative Thayer.
Thank you, Madam Chair. Again, I 100% support informed consent. I'm just concerned about the 24 hours and what additional stress it could put on women. And then the other, just a little concerned about that we are on line 20, giving a select group of legislators to intervene. But again, I do support informed consent.
Further discussion? Okay, Mr. Caldwell, if you call the roll on House Bill 117.
This is a roll call vote for House Bill 117. Representative Clouston,
Aye.
Representative Gugamas,
Aye.
Representative Heft, Representative McCann, Representative Ottman, Representative Thayer,
Aye.
Representative Wasserberger,
Aye.
Representative Yen,
No.
Chairman Rodriguez Williams.
Aye.
Madam Chairman, that is 8 aye, 1 no.
Thank you. House Bill 117 has passed committee. We'll move on to the next bill, House Bill 126, Human Heartbeat Act. Welcome, Speaker Nyman to Labor and Health and Social Services Committee. If you'd walk us through your bill.
Good morning, representatives. Good morning, Chairwoman Williams. Ladies and gentlemen, I bring you House Bill 126, Human Heartbeat Act. I'm going to ask for your favorable consideration. Ladies and gentlemen, I'll cut to the chase because I'm going to run out of time and I'm going to have to start a chamber and process up here. So the reality of this bill is right now based on current law or current decision-making being done in the state of Wyoming is that we have no regulation whatsoever or the prevention or the protection of the unborn in Wyoming. Quite frankly, we have the exact same laws as North Korea, China, and New Jersey, and multiple other states that allowed termination of the pregnancy all the way up to the time of delivery. What this bill attempts to do is to provide a line in the sand. This gives the unborn child of the right to be protected and the privilege of being carried to term after a fetal heartbeat is detected. Sadly, and I will tell all of you this, you guys know where I'm at on life. This does not prevent abortions in the state of Wyoming. Sadly, this does not also prevent what most abortions in the state of Wyoming are actually provided through, and that's through chemical means. Actually, this would provide a limitation only after that heartbeat is detected. And it's interesting to listen to the conversations talking about what are and are not rights. even if you go back, and if you'll give me, allow me a moment here to talk about, even going back to 1973 in Roe v. Wade, the court first formally recognized that states have a legitimate interest in protecting the potentiality of human life. That was in 1973 when this decision that was just overturned by Dobbs was actually was determined. And if you move forward to 1992, Planned Parenthood versus Casey, which you heard in the other discussion briefly, this decision reaffirmed the state's interest but shifted the framework, holding that the state has a legitimate interest in fetal life from the outset of pregnancy, not just after viability. So even through these determinations that are being made through the offering of the ability to be able to end innocent life, the life of the baby, courts recognize that states specifically have the right to determine restrictions on those rights. And now we go to what happened recently in the Dobbs v. Jackson Women's Health Organization in 2022. The Supreme Court, ladies and gentlemen, overturned Roe and Casey, ruling that the U.S. Constitution does not confer a right to abortion. This decision returned the authority to regulate or to prohibit abortion entirely to individual states. Wyoming is an individual state, allowing them to prioritize the protection of unborn life at any stage of development based on their own legislative judgment. That is what I'm asking of you today, is that this legislature would determine that life after a fetal heartbeat is detected is protected. That this is right, I said earlier, this is basically a line in the sand. So with that in mind, innocent human life is valuable and deserves protection in the womb. If you'll walk with me through the bill. Speaking specifically in State versus Johnson, this is in 2026. This is the court decision that you recently was discussing here and has been much cause of discussion around the state since that decision. The Wyoming Supreme Court interpreted Article 1, Section 38 of the Wyoming Constitution to include a right to make healthcare decisions, but acknowledged the legislature's authority under Article 1, Section 38, Subpart C of the Wyoming Constitution to enact reasonable and necessary restrictions to protect the general welfare of the people. The general welfare of the state of Wyoming and its people necessarily includes the promotion of humane standards of conduct and the prevention of the infliction of excruciating pain on sentient beings within the jurisdiction of the state. We have that right, ladies and gentlemen. Substantial medical evidence shows that an unborn child is capable of experiencing pain by not later than the unborn child reaching a gestational age of 15 weeks, as evidenced by the presence of sensory receptors, spinal reflex pathways, and hormonal stress responses to invasive procedures. We know that the baby feels pain and is sensitive to it. The state of Wyoming asserts a compelling interest in protecting the general welfare of its people by preventing the torture or inhumane treatment of any living human being whose heartbeat is detectable. Acting under this specific authority determined reasonable and necessary restrictions on the right of healthcare access to protect the health and general welfare of the people granted under Article 1, Section 38, Subpart C of the Wyoming Constitution. The purpose of this act is to restrict abortion procedures on unborn children with a detectable heartbeat. That will be Wyoming's, if passed, the line in the sand. Previous to that, there would be no limitations or restrictions on abortions. So, I mean, I guess to me, ladies and gentlemen, when I look at this, we're trying to find some place here that is palatable for everyone involved, but not throwing Wyoming's gates wide open to unlimited abortion. If there is something that needs to happen, or a lot of the discussion we've heard previously, the morning after pill and all these things, this would not deal with that. This would only be in place and enforced when a fetal heartbeat is detected through medical means determination. We can go through some of the new definitions. We created some new statute here. If you have questions on that, like I said, I do need to get upstairs. I wish I could stay for longer, but I want to give you time to ask me questions. If you have questions on the bill, I will make every effort to attempt to answer those questions for you. I would only submit to you this. In our Constitution, in Article 1, Section 38, Subpart C, and I will reread this for you as I've read previously from the chamber, and I believe it bears real weight in this discussion. The legislature may determine reasonable and necessary restrictions on the rights granted in this section to protect the health and general welfare of the people or to accomplish other purposes set forth in the Wyoming Constitution. I will challenge all of us to remember that if a woman is killed and she is found to have been pregnant under current Wyoming statute, no matter the gestational age of the child, that person can be charged with a double homicide. Therefore, already identifying the unborn as having rights and being protected. The state of Wyoming has made it very clear that we do believe in and we stand up for the perpetuation of life. It is a state responsibility. Governments were instituted, ladies and gentlemen, to protect life. That is why I believe at the very least that we can do as a state is when the fetal heartbeat is detected, that we would protect that life and give it a chance to come to full fruition. The other part of this I would read would go back into Article 7, subsection 20. It says, as the duty of the legislature to protect and promote health and morality of people, as the health and morality of the people are essential to their well-being. I would suggest to you that life is health, and the protecting of unborn life is health. It is interesting to me, and I know there's going to be folks that are going to be less than impressed when I say this in this room, but I'm really not concerned about that. The reality of it is Wyoming needs to recognize that human life is in the womb, the humanity of the unborn. The only way that you can justify abortion in reality is to say that that baby growing in that womb is not human. Our statutes clearly give that baby, human beings, rights under our federal constitution and our state constitution. I'm asking through this particular piece of legislation, House Bill 126, to at least establish that line. When a fetal heartbeat is detected and its little heart is beating, it needs rights. With that, I'll stand for any questions.
Thank you, Speaker Nyman. Committee questions for Speaker Nyman on the bill. Representative Klauston.
Thank you, Madam Chair, and thank you, Mr. Speaker. Just a question on detection. A transvaginal ultrasound can usually detect a heart rate beat at 6 to 7 weeks. The Doppler's at 10 to 12 weeks. If a facility only has the Doppler, how would that affect this bill and that medical person?
Madam Chairman, through you, Representative Klauston, according to the bill, it will be standard medical procedures, standard medical equipment to detect that heartbeat. So whatever that facility has, whatever that ability to be able to detect that heartbeat, if a fetal heartbeat is detected, the child is protected. So it's just heartbeat. There's no determination of age.
Further questions for the bill sponsor on the bill? Okay, seeing none. Thank you for joining us.
Thank you very much.
Sorry you have to leave.
I do. I've got to go and run a chamber. You guys have a good day. Thank you for your time.
Are there any government agencies that would like to come forward? This is on House Bill 126. Okay, seeing none. Please raise your hand if you plan on testifying on House Bill 126. Keep them up. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, I count. And then we do have some online. I've got 7 online. So obviously we're not gonna finish up here before we convene. We'll try and do the best job that we can. We'll limit time again to 2 minutes and probably have to reconvene after adjournment committee. So, all right, I'll open it up to public comment. We have 3 chairs up here. So please come forward.
Does Pepper have the time?
All right, good morning. Please state your name and we'll hear your testimony on the bill.
Good morning, Madam Chairman, members of the committee. I'm Mike Lehman with the Catholic Diocese of Cheyenne. I've probably listened to hundreds of hours of testimony on this issue over the last 10 years. And I tell pro-life people to listen to the debates. There's a lot of good testimony from people of goodwill on both sides of the question. The best of the testimony on those who happen to be on the other side of this question come from hearts that are genuinely concerned about the health and well-being of mothers. And I tell pro-lifers to listen to that testimony, internalize it, to help us draft the best legislation moving forward. Listen carefully, but also listen to what they will avoid saying at all costs. They will avoid acknowledging the mere existence of a preborn child. When you listen carefully, you understand that words are very powerful. Sometimes it's the unspoken words that say the most. I've heard from a few that this bill is unconstitutional and they cite the January 6th court decision, but I'll remind the committee what the decision actually said. In paragraph 2, it says, although we recognize the state's interest in protecting the life that an abortion would end, we conclude the state did not meet its burden of justifying the abortion statutes restrictions on a woman's right to make her own healthcare decisions. I'm not sure how the court can say that while reaching its conclusion without signaling to the world that it believes that life is not actually an inherent right like the Constitution states. Nevertheless, the decision nowhere says that the legislature cannot restrict abortion. And I would remind the committee of the words of our Chief Justice last Monday in her State of the Judiciary when she said, finally celebrate that the legislature has the last word. If a court has reached a result that is unpopular, the legislature can make a new law or propose a constitutional amendment or amend existing law. Therein lies the intended checks and balances between co-equal branches. Those were her words, and our governor also encouraged the legislature. So with that, I would stand for any questions.
Thank you, committee. Any questions of Mr. Lehman? Okay, seeing none, thank you, sir,
Thank you.
for joining us. Ma'am, please state your name and we'll hear your testimony.
Pro-life liaison for Wyoming Family Alliance and on the board of Laramie County Right to Life, and I am here in support of House Bill 126. Much of the debate around abortion centers on autonomy, that this is simply a woman's choice. But true liberty has never meant unlimited personal choice. Liberty does not include the freedom to harm the innocent. Every law this body passes recognizes that autonomy has limits when another human life is involved. We may not drink and drive, abuse a child or the elderly, or use illegal narcotics. We do not treat personal freedom as absolute when it endangers someone else because we are communal, social beings with a responsibility to those around us. No man is an island. My body, my choice only considers one of the lives involved. But abortion intentionally ends the life of a distinct human being with their own DNA. The question before us is not autonomy alone. It is whether that human life deserves protection. There is no serious biological dispute. From fertilization, a genetically unique, living human organism exists. Terms like embryo or fetus describe stages of development, not degrees of humanity. House Bill 126 addresses the point at which a heartbeat can be detected. To be clear, the heartbeat is not what makes a human being human. Life begins at fertilization. The heartbeat does not create that life. It is audible proof a life is already present. Cardiac activity can be detected just 22 to 23 days after fertilization. Evidence that this small human being is alive and developing exactly as human beings do. The only remaining question is whether some human beings may be excluded from legal protection because of their size, age, location, or dependency. History warns us what happens when societies decide certain humans are less worthy of protection. Grave injustice follows. Equal rights under the law rest on a simple principle. Human beings have inherent dignity just by virtue of being human, and innocent humans have the right not to be intentionally killed. If that principle is not universal, it is not a right at all, but a privilege of those with a voice.
Ms. Reister, you are out of time. My apologies. Committee, any questions of Ms. Reister? Representative Yen.
Madam Chairman, thank you. So I hear both Deacon Lehman and yourself as well that we're talking about the rights of a fetus. You can call it whatever you want. I can call it whatever, that's fine. I think it's actually different. And so when I think about this, I actually think about whose right is it to make sure that that fetus turns into an actual birthed child? And is it the right of the government to tell a woman that she has to carry that child all the way to term? I actually think the line is, when that fetus can be viable by itself, I think that it's fine because it no longer requires that someone else's rights be infringed for that individual's rights to exist. And so I guess the question from me to you is, why should we tell a woman that they have to carry something to term, it infringes their right for another individual's. Am I required to tell you that you have to make sure that Mr. Lehman stays alive no matter what? That would be my question. Thank you, Madam Chairman.
Ms. Reister, if you'd like to respond.
Madam Chairwoman, thank you. And Representative Yan, thank you for your question. I don't think that those two things are comparable at all. Over 96% of the time, a reproductive act reproduces and creates a human child. And after that, you have a responsibility to your offspring, which is what fetus means in Latin. And those approximately 4% numbers differ when it is not the choice of the woman to have conceived that child. That does not change that that child is a human being. And regardless of the egregious and heinous violation that has occurred upon that woman, it does not change the humanity of that fetus or child.
Further questions of Ms. Reister, committee? Okay, seeing none, thank you for joining us.
Thank you.
Sir, if you'd state your name, we'll hear your testimony.
Good morning, Madam Chairman, members of the committee. My name is Steve Millier from Cheyenne, Wyoming here. It's been talked about the rights of a woman. She can choose to kill her own children. Well, I come up here with a responsibility. I think women have a responsibility. I don't care how they get pregnant. I was in the Navy for 31 years, and I know a lot of guys that were sent overseas to foreign wars. They had a responsibility. They had an opportunity to be killed themselves. But they held that responsibility and didn't say, "Oh, I have a right to just get out of this war and whatnot." So we know what responsibility is, and we have a right to defend our own lives. But we do have a responsibility to other lives. Why do we like killing people? I mean, we've killed people for 10,000 years. We've dehumanized a lot of people. We dehumanize this fetus. Oh yeah, it's an inanimate object and whatnot, unlife and whatnot. We like to change words saying that, oh, it's just a fetus. No, it's a human life. Again, why do we like killing people and saying, oh, I have a right. It's my body. I can do with what I want. A woman cannot shoot drugs into her system. She cannot be a prostitute. She cannot do other things just like us guys. We cannot do drugs. We cannot prostitute ourselves and whatnot. We have responsibilities. And I would like to tell the guys, we get a woman pregnant, we have a responsibility to support that woman all the way straight through, at least until the child is 18 years of age. Sure, we have rights, but as previous speaker mentioned, it's not all the way straight through. My body, my choice. Well, I can't do a lot of things, and I have a responsibility to society, okay? And a woman has a responsibility. She had the right to have sexual intercourse, and there's 18 to 24, depending on how you count, methods of birth control. Why didn't she use those? Why didn't she tell the guy to use them? We have responsibilities. And again, why do we like dehumanizing? Why do we like killing other people? A lot of people enjoy killing other people, but that doesn't give them the right. And we have a responsibility, all human right to—
Mr. Milia, you are out of time.
Darn.
Committee, any questions of Mr. Milia? See none, sir. Thank you for
Thank you.
joining us. And audience, I might add, if you do plan on testifying and you occupy one of these 3 seats, I'd ask you to just face the committee, please. Let's not intimidate or try to make our public testimony uncomfortable for anybody. Thank you. Ma'am, please. Oh, actually, sir, you're next. So go ahead.
Is that okay?
Yep, please state your name and we'll hear your testimony.
Hi, my name's Greg Hunter from Laramie, Wyoming. I didn't want to opine about the Roe SCOTUS, which they basically said in the punchline, while we could have held that a woman has a full term, we're going to ignore that obvious right as we don't trust women, so you only get 3 months. So I just want to point that out. The submission of this bill is just proof that Dobbs was not founded on a plain reading of our Constitution and the Bill of Rights by reasonable people. The party that whined about DEI restricted their SCOTUS choices to those that would be obtuse enough to decide that the power of the state should be used to fulfill a nosy neighbor's desire to manage a woman's womb. They decided that 3 months Roe set aside for the citizen to decide was just too much. And so they disingenuously let the people of each state decide. Reasonable people are not stupid. In fact, when Roe Dobbs came down and this bill was passed in my birth state of Ohio, the people rose up and defended a citizen's privacy rights and also made marijuana legal. The GOP overreached reasonable people's understanding of our Constitution and the Bill of Rights in Ohio, and they rose up. This body was told that the courts would strike down your poorly thought out decision, but instead of learning the lesson of Ohio, they ignored the warning and will attempt to corrupt the Wyoming justice system like the GOP did to our Supreme Court. I'm a regular listener of right-wing radio in Wyoming, and now that many of the citizens have had time to think, they are deciding that Roe was the right compromise. I think Roe was crap, as a far better U.S. would be created if we built a country where women felt comfortable and supported introducing a new citizen for this country to educate and regulate. How much is this body costing Wyoming taxpayers by wasting time and money spent defending this body's unconstitutional legislation? I'll stand for questions.
Any questions of Mr. Hunter? Okay, seeing none, thank you for joining us. Ma'am, please state your name and we'll hear your testimony.
Thank you, Madam Chairman, members of the committee. My name is Britt Borrell. I am the Executive Director for WYO United. Following the Supreme Court ruling last month, the governor asked for this legislature to take a constitutional amendment to the people for a vote on the question of abortion for a reason. All of the legislation this body is attempting to pass limiting access to care is unconstitutional. In passing it, you would only be inviting more lawsuits, costing the taxpayers money in the process. In other states, when heartbeat bills like this have passed, they have effectively implemented a 6-week abortion ban. A fetus does not even have a developed heart at this point, but rhythmic electric pulses are detectable via invasive transvaginal ultrasound at 6 weeks, which is why many states have interpreted it to constitute a heartbeat. Many women do not even know they are pregnant at 6 weeks. This bill is clearly unconstitutional as it impedes a woman's right to seek abortion care, which the High Court has ruled is health care protected by the Wyoming State Constitution. This bill states that its interest in implementing this ban is to protect fetuses from experiencing excruciating pain and cites incorrectly and without evidence that fetuses can feel pain starting at 15 weeks. The American College of Obstetricians and Gynecologists states that fetuses cannot experience pain until at least 24 to 25 weeks gestation. Contrary to the speaker's statement that patients in Wyoming can seek abortion up until birth, the current viability limit for abortion in Wyoming is 24 weeks. As we've seen in many states which have implemented bans like this, even with exceptions, women are suffering, losing fertility, or dying because they do not have ready access to abortion care they need, whether that's because providers leave the state or because they fear repercussions for providing life-saving care. Additionally, many fatal fetal anomalies are discovered at the 20-week scan, a fact that is not considered in this ban. Personally, I believe that this body chose not to take a question of whether abortion should remain safe and accessible to the people of Wyoming for a vote this fall, because they know that the majority of Wyomingites would vote in favor of keeping abortion safe and legal. The stated interest of the state in this bill to limit our access to healthcare is flawed and inadequate and does not meet the strict scrutiny standards for interfering in our healthcare decisions and is therefore unconstitutional. Please vote no.
Committee, any questions of Ms. Worrell? Okay, seeing none, thank you for joining us.
Thank you.
Ma'am, if you'd state your name and we'll.
Good morning, Madam Chair, members of the committee. Wendy Volk from Cheyenne. I'm speaking as a private citizen. I respect the convictions behind this bill. My concern is constitutional durability, public health, and the principle that in Wyoming, pregnancy has historically been private, not political. As previously mentioned, the Wyoming Supreme Court ruled protecting the fundamental right to make one's own healthcare decisions and determined abortion qualifies as protected healthcare under the Constitution. The court applied strict scrutiny, the highest standard of review. Under strict scrutiny, a restriction must serve a compelling interest and be narrowly tailored. House Bill 126 prohibits abortion once a detectable heartbeat exists, often around 6 weeks, and imposes felony penalties and mandatory license revocation. Courts will examine whether that categorical prohibition is narrowly tailored under the framework of the court has already established. Public health outcomes also matter. National data shows that maternal and infant mortality rates are higher in states with the strictest restrictive abortion bans, such as Texas. When access to timely care is reduced, risks increase. Wyoming values limited government and personal responsibility. Pregnancy decisions have long been treated as private medical matters between a woman and her physician, not criminal matters. Strong convictions deserve strong drafting that will withstand constitutional review and protect real families. I respectfully urge you to vote no. Thank you, Madam.
Thank you. Committee, any questions of Mrs. Volk? Okay, seeing none, thank you for joining us. Ma'am, if you state your name and we'll hear your testimony.
Dear Chairman or Madam Chairman and committee members, my name is Laura Pavey, and I thank you for the opportunity to speak today in support of HB 126, the Human Heartbeat Act. Human life begins at conception. At the moment, the distinction and a living human being organism comes into existence with unique DNA and a continuous path of development. This bill recognizes a biological fact that is already in motion. A detectable human heartbeat is not symbolic. It is measurable medical evidence that human life conceived is alive and actively developing. The heartbeat is a living member of the human species. That distinction matters because human life carries a unique moral, legal status under our laws. Protecting innocent human life falls squarely within this responsibility. The heartbeat doesn't create life, it confirms it. In every other context, we understand the continuality of human development. An embryo, a fetus, a newborn, a child, an adult. There are not different kinds of humans. They are the same human at different stages of maturity. We would not dismiss a premature infant in neonatal intensive care as just tissues because they are small and dependent. We recognize that patients, because of they are human beings. Before birth, the only difference is location. Development remains continuous as conception moves forward. In scientific terms, every single cell organism would be recognized as life if it was discovered everywhere else on the universe. Yet here, when life, a living human organism with organized development and detectable heartbeat exists in the womb, some reduce that life to just cells. Every human being is made of cells. The question is not whether or not something is made of cells. The question is what kind of organisms those cells come from.
Ms. Pavey, you're out of time.
Thank you.
Committee, any questions of Ms. Pavey? Okay, see none. Thank you for
Thank you.
joining us. Ma'am, please state your name and we'll hear your testimony. And you'll be the last two.
My name is Maria Ward. I work for the Catholic Diocese of Cheyenne as the Project Rachel Coordinator. I want to speak a little bit about when people seek to contact me for healing after they have experienced an abortion. Many times it's been many years since their abortion. There has to be something that happens that helps them realize they are not healing from this and they need to reach out. Oftentimes, the thing that triggers their realization that they need to seek help was when they acknowledge that they ended the life of their child. And with this bill, the heartbeat bill, we would be able to help them realize it takes away the abstractness of the child in their womb and really brings it to life. We all know that a heartbeat is an essential part of our life. And so I feel like it would really help a lot of these women who are in such severe distress. They're in shock, they're in concern, finding out that they're pregnant, being able to have the law help them make an informed decision in this case that they have a child in the womb, it is a living being, will help prevent years of grief and distress over choosing to end the life of their child. I'd stand for questions.
Committee, any questions of Ms. Ward? Okay, seeing none. Thank you, ma'am, for joining us. Ma'am, please state your name and we'll hear your testimony.
Madam Chairman, thank you for having us here today. My name is Katie Gieser and I'm a citizen of Cheyenne. I'm also on the board of Laramie County Right to Life. Mine is just simple and short. This isn't just about the woman's health care. It is also about the unborn human's health care. The unborn human is reliant on the mother for its safety. This human is not a part of the woman's body. It is attached to her. We have a duty to protect that life. This is very different than any other medical procedure. It does involve another human who cannot speak for himself or herself. The very fact that there can be a separate heartbeat detected inside the woman's womb should be reason enough that we should know that we have a responsibility to protect that life. As a woman and mother, I urge you to vote yes to this bill. Thank you.
Thank you, Ms. User. Committee, any questions? Okay, see none. Thank you, ma'am, for joining us.
Thank you, Madam Chairman.
All right, committee, so we did not finish public testimony. We have potentially 7 online is what we counted in the beginning. So we will carry over after adjournment to hear the remainder of public testimony and then work the bill if it's the committee's desire. So Mr. Caldwell, if you would notice that meeting, that would be great. Any members of the audience, you're welcome to join us. I have no idea what time we will adjourn. Sometimes it is late, but you are welcome to come back and join the committee as we work the bill. Okay, with that in mind, this meeting is adjourned.